Thank you, and good evening, everybody. Welcome to the Orange County Courthouse. I'm Bob Egan, a circuit judge. Those of you who've been here before have seen me, I'm sure. I've been a judge for almost 17 years, and I'm currently assigned to juvenile dependency, which is not a topic we're going to be addressing during this series, but hopefully we'll get back to that very quickly. We're very excited about the agenda we have, not only today, but for the next 2 weeks, and we sincerely hope many of you will be able to attend more than one of these presentations. Next week, for example, we'll hear from Judge Alicia Lattimore on something called problem-solving court. Fascinating area. You know, does everybody who gets arrested have to go through the traditional process? Maybe not. If you're a veteran, maybe you can be treated differently. If you have a substance abuse issue, maybe you can be treated differently. Mental health issues and things like that. But she's going to be talking to us about problem-solving court, some alternatives to traditional practice of law in terms of criminal justice. And then the week after that, we'll have Judge Diana Tennis. She'll be talking to us about divorce court and how divorces work and things like financial issues, child support, child sharing, alimony, and things like that. So we really are looking forward to those two presentations. Tonight, we're fortunate enough to have Judge Diego Madrigal with us, and he's going to be talking about searches and seizure. For those of you who like to read the Constitution, he's going to be talking about, I think it's the Fourth Amendment, is that right?
It's the fourth one.
Okay, it's the Fourth Amendment related to unreasonable searches and seizure. What is an unreasonable search and seizure? I have no idea, but we're going to find out tonight, I hope, okay? Judge Madrigal, he's a double gator, for those of you who that matters. He went to undergrad and graduated from law school at the University of Florida. He was appointed to be a circuit judge in 2019 and then was elected 20 or 22? 20. In 2020, he was elected, I believe that was without opposition. Okay. Before becoming a judge, Judge Madrigal was a civil trial attorney. He primarily practiced plaintiff's personal injury, but he certainly knows his way around a courtroom. He was recognized as a rising star in our legal community 3 years running by the Super Lawyers magazine 2016 through 2019. I'm told and I've heard he is extremely proud of his Hispanic heritage. He has a Cuban father and a Peruvian mother, both of whom immigrated here from those two countries. I saw Judge Madrigal give a promotion for National Hispanic Heritage Month a couple years ago, and this is what he said, okay? He said some things about how proud he is of his heritage, and that's fine, but he also said that because he has a Cuban father and a Peruvian mother, he's a fantastic dancer. You've got some immutable characteristic of everybody who's Hispanic. I've known him for 8 years. I've never seen anything to even suggest he's even a moderately good dancer. But maybe he needs to prove that tonight, okay? Judge Madrigal has handled cases in Osceola County Unified Family Court. He's been an associate administrative judge also in Osceola County. He currently presides in a felony circuit civil division, so he deals with things such as search and seizure almost on a daily basis there. Please, can you help me welcome Judge Madrigal?
All right. Thank you, Bob. All right. Good afternoon, everybody. All right. So this is actually going to be a very quick topic. Very quick. The Fourth Amendment was written in 1789. It says that people cannot search you without authority from a judge. And we're done. Any questions? No. So that is what the Fourth Amendment says, and the Florida Constitution says the same thing. So people are protected from unreasonable searches and seizures unless there is authority by a judge supported by an oath from somebody applying for it. So the way that usually works is an officer, so a cop, detective, comes to us with a sworn affidavit saying this is the reason I need a warrant, and the judge will sign or reject the warrant, and that's how a search occurs. Now, that seems simple. It is not as simple as it seems. There have been judicially created exceptions to that requirement. So, The exceptions are generally falling into certain categories. Let's go through them. The first one would be an emergency or an exigent circumstance. Emergency and exigency mean the same thing. What that means is that there is not enough time to get a warrant. Okay? It has to deal with safety. So the emergency has to be so apparent that it is imperative to the safety of the police and the community to get a search warrant. Think about something where somebody's life or safety is at risk. That's what we're talking about when we talk about an exigent circumstance. It can mean destruction of evidence. You think somebody is going to flush drugs down the toilet and the evidence will be lost forever. You probably wouldn't need a warrant for that search. Another exception is consent. An officer or detective walks up to you, says, "Can I search you?" You say, "Yes." They're allowed to search you because you've consented to that search. You don't need a warrant for that. And we're going to get into more details on all of this in a second, okay? The vehicle exception. The law says, the Supreme Court has said, that when an officer or deputy or detective has probable cause that there is evidence of a crime or contraband in a vehicle, they can search that vehicle. Okay? There is also search incident to arrest. If somebody gets arrested, the officers are allowed to search that person right after the arrest. We have inventory searches. Think of a situation, well, sorry. So law enforcement oftentimes takes people's property, right? They arrest somebody and something's abandoned. Think somebody leaves their car on the side of the road. So most police departments, I think all of them, have protocols in place to search that car for inventory, meaning they record everything that's in the vehicle, and that's so they can protect themselves and return all that stuff to whoever is the proper owner of it. Okay? So searches incident to that are also exempted from having or needing a warrant. Okay? So seems easy enough, right? Seems pretty easy. It is in fact not as easy as it appears. Let's do some examples. Okay, so Jane is taking out her trash to the curb. She hears her neighbor say, "Oh my God, don't kill me, he has a gun." Okay. Jane calls the police. Police show up, knock on the door, nobody answers. Can they go inside? Yes.
Yes.
Okay, who agrees with yes? Does anybody think no?
No.
You don't think so? Why not?
Because they do not have the approval by anyone present.
I think James Madison would agree with you. The Supreme Court does.
Okay.
So, a situation like that could be an exigent circumstance. They heard of somebody say, "He's going to kill me," or it's been reported to them that somebody said, "He's going to kill me. He has a gun." So somebody's safety is potentially at risk, so the police will probably be allowed to enter that home to search. Okay? Let's use the same situation, but they see... okay, let's do this one. A detective is driving down the road and he sees a man he's arrested previously for drug trafficking. The guy walks into his home, doesn't have anything in his hands. Officer says, "I know that guy's a drug trafficker," and goes to the door, knocks, nobody answers. Can he enter that home? No. Okay, so you guys got it. Okay. So, let's change the scenario a little bit. Same scenario. but somebody answers the door. The officer says, "Can I come inside?" The person says, "No." Can the officer go inside? No. Okay. What about if the person says, "Yes"? Okay. What about if the officer calls backup, and when the person opens the door, there's 10 guns pointing at the person saying, "Can we come inside?" He says yes. He says yes. Well, why?
No, because you'd be under duress.
Okay. Did you read my outline? All right. All right. So that is a situation that the law would probably find is not freely and voluntarily given. So a person who is consenting to the search needs to do that freely and voluntarily. They can't be forced to consent. Okay, so the law, all this is hazy and really fact dependent, okay? It's all fact dependent. So in a situation like that, they probably could not do a search or go into the home. Let's do another example. Now we're going to get a little more complicated and nuanced, okay? So this is not in the outline. It is in the outline. But, all right, so John gets into an argument with his wife, Jane, okay? John says, pulls a gun on her and says, "I'm going to kill you." She calls the police, and he leaves with the gun in his car. Okay? Police see him 3 minutes later going down the road, pull him over. Can they search the vehicle? All right. Why?
Yes, no.
You know why. Who says no? All right, why not?
No one's in danger.
Okay.
He said no one's in danger.
No one's in danger. Okay. Does anybody agree with her? Anybody disagree with her? All right, this young lady here disagrees with her.
Well, how do you know no one's in danger?
Okay. So if you remember the exceptions I gave at the beginning, one is a vehicle exception. So he's in a car. Okay? Cars move. Cars move. So if you remember at the beginning, we talked about preservation of evidence being one of the things that people look at. If you notice what I asked, I said he left with the gun. He left with the gun. So can they search the vehicle? Yes, probably. He gets arrested now. Okay, so they arrest him for aggravated assault with a firearm, domestic violence. He's removed from the car. Can they search the vehicle now?
Yes.
Yes. Yes, they can. Same rationale. Okay, let's change it a little bit. They see a backpack in the back seat. Okay? So he's already been removed from the car, under arrest, he's left. Can they search that backpack? Not inventoried yet. They're not towing the car, so it's not yet an inventory. It might get there, but it's just a backpack. They take them out. They see the backpack. Can they search that? Mike Brown, do you know? They can, correct. They can search the backpack. You can search all containers and all compartments in the vehicle with some limitation. With some limitation. It has to be calculated to lead to actual evidence of the crime which the person is charged with. So, he had a gun. Can a gun fit in a backpack? Yes. So you can search the backpack. Okay? Now, let's say, let's change it a little bit. He's charged with kidnapping. Kidnapping. They pull over a car. This person's charged with kidnapping. Can they search the trunk? Yes. They find, again, same scenario where he's already been taken away. They find that bag in the back seat. So it's only kidnapping, there's no firearm. Right? Can they search the bag that's in the back seat? So it's kidnapping. All right, why not? Anybody?
The person's not in the backpack.
Because a person cannot fit in a backpack. Correct. So you have to limit the search to something that could lead to actual discoverable evidence. Okay? Let's change this a little bit. Person's on a bicycle now. Person is on a bicycle. Actually, let's go back to the other one. Because there's one thing that is important that I missed. Okay. So they are searching for the body. They open the trunk up, and they see 5 kilos of cocaine in there. He was charged with kidnapping. They open the back. They see 5 kilos of cocaine. Can they use that in a case against him? Why you say no? Why do you say no?
I just don't think they would let them because of the technicalities.
Okay. Anybody say yes? You say no? No. No? No? Who thinks it's no? Raise your hands. Who thinks it's yes? The answer is yes. The answer is yes. So because they were searching for the body, they opened the back. Okay? If they just see something in the back when it's part of a reasonable search, they can use that evidence to charge him. Same with the gun example. If they had opened the bag thinking there might be a gun in there and they found drugs, they could charge those drugs as well because they were searching for something that they had a reason to search for, a legal authority to search for, and they open the bag and they find something else. They can use that against them. Which, this is an important thing that I forgot to mention. When we talk about using it against him, the remedy for an illegal search and seizure is generally suppression of the evidence, meaning you cannot use that evidence against the person to prosecute that crime. So it's called the exclusionary rule. The exclusionary rule says if you get something through an illegal search, you can't use it in a case. Right, Ms. Perez? Yes, sir. All right. So, let's go back to the bicycle now. Okay, so, guy is, threatens his wife, pulls a gun on her, leaves the house on a bike. Police pull him over, arrest him, take him away from the bike. He has a bag on the bike. They take the bag. They put it on top of their cop car, sit him on the curb. Can they search the bag? Who says yes?
What was did he have a gun or what did you say?
It was the same, he pointed the gun at his wife and said, "I'm going to kill you."
Yes.
Yes.
Okay. All right, ready?
Yes.
Who knows the answer? Mr. Morales, do you know the answer?
No.
So would you believe that the 6th DCA last year said no? 6th DCA is our state appellate court. They say no because they say a bike is different than a car. And if he had already been arrested, it had been removed from him, he can't access it, there's no officer safety issue, there's no destruction of evidence possibility, they could go get a warrant. So go get a warrant for it because he's on a bike. He's on a bike. So I told you it gets trickier. I told you it gets trickier. All right. Does anybody have questions about anything we've covered so far? Yes.
What happens to the cop who does the wrong thing?
So that's a good question. Generally, nothing. And I don't mean that in a facetious way. A lot of the times they have a good faith basis for searching. So, you know, I'm a pretty fair guy. Judge Egan's a pretty fair guy. sometimes we make mistakes and an appellate court tells us, you got it wrong. So people make mistakes. So the same thing applies there. There's consequences to your mistake. That consequence would be you don't get to use that evidence in that case. If it is a situation where it is so egregious, something where they are just completely violating somebody's rights, obviously there can be some civil liability, there can be disciplinary, they can be put on certain lists that affect their credibility. Ms. Perez can talk to you more about that. Yeah, there's something called a Brady list. I don't want to get into that right now, but there can be consequences if it is very egregious conduct. Generally, if it's an innocent mistake, they just didn't know or didn't do it right, it just gets suppressed. And I'm sure their supervisor speaks to them and legal counsel probably speaks to them too. But I've never worked for a law enforcement agency, so I don't actually know what happens.
Your Honor, what happens if okay, so the person gets arrested just based off of someone said that he threatened me and he had a gun, like or domestic violence, let's say, and he had a gun. So do they do any investigation? Do they automatically go after the guy to arrest or the female, whomever?
That's a great question, and I'm taking shortcuts. So I'm taking shortcuts. Before you do an arrest, you have to form probable cause. So you do have to form probable cause for an arrest. So that example is assuming that the police investigated it enough to form probable cause for an arrest. Now, you don't necessarily need probable cause for a search. It depends. It depends, and we'll get into that in a little more detail later. Okay, so, but yeah, I'm taking shortcuts.
Okay.
I'm taking shortcuts. Any other questions on what we've discussed so far? Yes, sir.
I'm going to mash up a couple of yours real quick. So if the guy has a gun, goes in the car, and the gun is sitting in the passenger seat when he gets pulled over, but he has a backpack in the back with cocaine in it, how do they settle that?
That's good. Good question. So what is the scenario there? Is it the same scenario I gave? Yes. Okay. So I have to be careful I don't violate judicial canons. Hold on. That might be okay because in the scenario I gave, they didn't specify which gun. So the police don't know if he used the gun on the seat or if there's another gun that he potentially used for that offense in the back. So they probably would be able to search both. Probably. But it depends.
So then it would come up in inventory then, wouldn't it? If they
So-
decided not to search the backpack.
Right. So eventually, a lot of the stuff comes up in inventory later on, but inventory is only after an arrest. Inventory is only after an arrest. So there's scenarios which we're going to get to where people are not arrested but searched. So just search instant to an arrest is one way to search somebody. It is not the only way to search somebody. So there are ways to search people and not arrest them. For example, anybody been pulled over? You've been pulled over, ma'am? For what? Well, is the case still pending? The case is still pending? It is? You look like a speeder. You look like you might speed a little bit. Okay. All right. So let's talk about that. Who wants to volunteer their being pulled over story? All right. Yes, ma'am.
I was pulled over yesterday.
I can't talk about that one. That's still pending.
It is still pending.
Did you, which county?
Orange.
Did you get arrested?
I did not.
Civil traffic?
Yes, speeding.
Are you challenging it? Let's make it easier for me. Let's pick somebody else. Oh, they got somebody back there.
Yeah, mine's closed. I paid it a while ago. So I got pulled over for speeding on the 408, going to the July 4th watermelon run.
Oh.
And I got a speeding ticket, and I paid it.
You should have told him James Madison in 1789 wouldn't have liked that.
I told my son it was an expensive tank top because he really wanted to do the race. And
Did he finish it?
he finished it, and we have a $300 tank top.
Yeah. All right.
But I was speeding, so
Well, thank you for your honesty.
yeah.
Okay. So you get pulled over. Did the police approach you?
Yes.
What did they ask you?
For my license and my registration and my insurance card. Oh, sorry. For my information.
Okay. Did they ask you to search your car?
They did not.
Did they look into your car?
Yes.
Okay. Did you have any contraband there?
No.
Okay. What if you did?
I guess they would
Could
have
they
seen
have searched it?
If they saw it, yes.
All right. Who thinks you can search that?
If he sees it, like there's not plain view if he saw it.
Can they take it from you? You have a kilo of cocaine in there.
Sure. I didn't, but if I did, they could take it.
In a hypothetical situation, not you,
Right.
but in a hypothetical situation, there's a kilo of cocaine sitting on your son's in the back, cocaine's in the front seat. Walk up to it, see it.
They can take it.
They can take that. Who agrees? Right. It's in plain view.
Right.
It's in plain view. Now, let's say you're rolling down the street and you're smoking marijuana. You're smoking marijuana down the street, driving, smoking marijuana. Officers approach you. You roll down your window, a cloud of smoke comes out. Your son's in a tie-dye tank top. Okay? He's in a tie-dye tank top in the back. All right? Can they search you there? Can they search your vehicle?
Yes, because they can
Okay.
plain smell.
Okay. You want me to take this one? It depends. So there is now conflicting case law. I don't know if you guys have heard, so we have medical marijuana. There's also a hemp statute. Hemp, apparently, smells the same as marijuana. So some courts say that you can't search because nothing indicates a crime or criminal activity. Some courts say you can search. So it depends on your judge. It depends on your judge and on the circumstances. So, for example, like medical marijuana, you can't smoke that in a car. Let's say you're walking down the street and you smell like marijuana because you left your clothes at your cousin's house, and your cousin, big marijuana user, loves marijuana. Your clothes now smell like marijuana. You're walking down the street. Can a cop stop you there? I've left you flabbergasted. Most of my answers are, it depends. So it depends. Somebody smelling like marijuana, is that a crime? Is smelling like marijuana a crime? Right. So probably couldn't. Now, let's say the police come up to you and ask you, can I search you? Well, doesn't it depend on your answer? What if you say yes? Later on you challenge it. If you said yes, can they search you? Haven't pulled guns on you, just come up to you, say, hey, can I search you? You say yes. Bob, what say you?
If I say yes,
Yeah.
hey, they search me all day long.
Search you all day long, and that's okay. Okay. Yes.
What about in the car if they think that you're under the influence of the driver?
So that's a little bit different. Under the influence. Oh, sure. So the question is, what if you were driving the car, but the officer decides that, or thinks that you are under the influence of what? Marijuana? Okay. Then, do we have something that, is it legal to drive under the influence of marijuana?
Not to the extent you're doing faculties are impaired.
Okay. But do they have to prove the case right then and there? No. They just need what to search. Right. So, they can search it.
So,
Yes.
the probable cause is a bag of oregano, and it's probable cause because you think that it's marijuana.
so there's also something called a good faith exception. So the case I was just talking about where somebody was driving and the police smelled marijuana and they searched, the 5th District Court of Appeals, that's based out of Jacksonville, or Daytona, but soon to be Jacksonville, they say that you can't search based only on the plain smell, but that search in that case was okay because the officers had a good faith basis that the law at the time allowed that search. So the law previously was universal, that you can search based off plain smell of marijuana. That case has changed it. So they said, you can't do that, but since you thought you could do it at the time you did it, officer, that search is okay. So, I know, it's clear as mud. It's clear as mud. If I could, I can't give legal advice anymore, but just don't do drugs, anybody? Don't do drugs, don't sell them, don't do them, don't courier them, just don't do anything, okay? All right. Any other questions on that? All right. So we already kind of talked about inventory searches. Let's just touch on that briefly. Let's go back to our example with the kidnapping. So there's a small bag in the back seat. We all agree that can't be searched, right? Because they're searching for kidnapping, can't search that bag, right? Anybody disagree with that? Okay. So they take the person away, they arrest him, the car's abandoned on the side of the road. The police say, we got to tow this thing. So they show up, they start looking in the car and taking inventory of everything. They open up the trunk and they find, I don't know. I keep using drugs, that's the easy one. What was it? A dead body in the back seat. Dead body in the back seat of that car. Or back trunk of that car. Okay? Can they use that? Right, because it was part of an inventory search. So an inventory search is just making sure you take account of everything that's in the car. Now, if you go to court and you're challenging a search, do you just get up there and say, oh, it was an inventory search, so the lawyer gets up there, let's ask Ms. Perez. No, Ms. Perez. Lawyer gets up there, state, you know them. State gets up there, doesn't call a witness, says, Judge, inventory search, I'm going to find it anyway. It was part of the inventory search, it's all good. Deny the motion to suppress. What do you think about that? Come on.
What do I think about if the attorney says?
Yeah, the attorney says it.
I'm a defense attorney, so that's what I would say. You're saying, what would the state say?
No. The lawyer says, in argument, Judge, yeah, they didn't have a warrant, but it's an inventory search, so they would have found it anyway. What would your argument be back to that?
I'm not sure what position I'm in. If I'm the
Your
judge,
position, McDowell Perez.
as a defense attorney,
In your current position.
I would argue it's an inventory search. It doesn't mean anything. If I was the state, I would say, of course it does. It was a compartment in a vehicle. I opened it.
Where's the evidence it was part of an inventory protocol?
Hey, what do you mean by that?
They got to introduce evidence of what their inventory procedures are.
Right.
So they didn't. They just say, get up and say.
I'm sorry, I didn't talk about procedurally. What
Right.
the state doesn't.
Yeah, sorry, this is getting complicated.
I know.
So you can't just have what a lawyer says is not evidence. So you have a lawyer get up in a hearing and say, we would have found it anyway to inventory search. That's not enough. That's not enough. You have to introduce some evidence that was their inventory procedure in order to search it. You can't just have people coming up, I'm not going to say making things up, but just saying things without a basis for them. If somebody testifies that that's their inventory, that might be enough. It's even better if they introduce the actual inventory procedures to the court, because then there's no doubt that they would have found it anyway because these are the procedures they follow. So any questions so far? Yes, ma'am.
Would any of this have changed if the person who had done the the bad thing was not here legally? Would that have changed any of these scenarios?
So you're not going to like the answer? I don't think I can comment on that because that's a current legal issue that I could be facing in cases that I handle. So I don't think I think the judicial canons do not allow me to answer that question.
What was the question?
But Bob might. Does it change any analysis if the person's an illegal immigrant?
It shouldn't. I'm unaware of any authority that says if someone here illegally is pulled over or something like that, their immigration status gives probable cause to search. I also don't think a police officer would know that someone is here illegally or not, and I'm unaware that they're authorized to say, show me why you're here. So I don't think the analysis, Judge Madrigal, changes. Either there's probable cause or not, and I don't think their immigration status would impact. That's
I think there's some legislation coming down the pipeline. So that's why I didn't comment on it.
Well, the law may change if by statute, but that threshold question would still be, what could a police officer, for example, if the legislature wants to change the rules of how we treat someone here, if not legally, an immigrant, searching them. They want to change that for that criteria, that category of people. There still has to be a mechanism by which the police officer would know whether this person is here legally or not. Are you a citizen? Do you have a green card? Are you on a visa? I don't know how the legislature proposes that would take place. But if there is an easy way to determine somebody's status and the law says that is something a judge has to take into consideration, then yes, Judge Madrigal in his cases would have to do that. I would just be curious as to how they would determine on short notice somebody's status.
Well, typically, if the legal immigrant wouldn't have a driver's license, so they would know almost immediately when they pull them over.
No driver's license?
Yeah, no driver's license. The legal immigrants cannot get a driver's license. So when they get pulled over, they ask for a driver's license. They don't have one in general. No, you're absolutely right.
Some people also leave their driver's licenses at home a lot.
How do they know if they're illegal? They would know by pulling.
But if even that's the case, it could be a bicycle, it could be something on the street. I think right now, at least, the analysis of whether there's probable cause would be the same for somebody who was born here versus somebody who was not.
Okay. So let's talk a little bit about that topic. Oh, I'm sorry. Oh, she's my favorite.
In the case of
I'm sorry that I've had you in the courtroom so long. She's our court reporter. She's wonderful, but I talk a lot and I talk fast, and so this is my public apology.
You're forgiven.
To the interpreter as well.
In the case of an inventory search, does it matter if the person what if the person is not the owner of the vehicle?
That is a wonderful question. So let's talk about that, and I'll come back to that part at the end. Anybody here have roommates? Or people who you share space with, you share stuff with, you share a car? All right. So police arrive at your home. Police arrive at your home. You have a roommate, and they say, can we search the home? And you say, I have nothing to hide. Yeah, come on in. And they go into your roommate's room. It's locked. They break the lock, go in, and they find some contraband. What about that? So you gave them permission to come into your home, right? What do you think, beautiful young lady in the front row?
I'm his wife, so.
I assure you we have no contraband at home. We have a lot of dog treats.
No, they cannot go in that room.
Who agrees with her? She's very smart. Very smart and very beautiful. And she's very right. She's very right as well. So they probably can't go into that room. It's locked, they can't go into. Let's say you share a vehicle with somebody. You both share a vehicle, 50-50. You get pulled over. Police officer asks you, hey, can I search your car? And you say, yes. They find, let's say, I hate using drugs again. Well, weapons may or may not be illegal depending on, but let's say they find, let me give you a better example. I'm going to give you a better example. Okay? This is actually a better example. You are driving with your roommate. Your roommate's been drinking. Your roommate's been drinking. You drive their car home that you share. So it's not their car, it's both of your cars. Your roommate flashes a gun out the window, shoots at somebody, police come, they arrest. That's a bad example too, hold on. Okay. Should have thought this through more. But you guys have very good questions, so I'm trying to. So, police come, pull you over, take you both out of the car. Okay? They ask you, hey, can we search the car? Can we search everything in the car? Can we search the car? And you say, yeah, go ahead. Okay? You both own the car, you both drive it, you're both on the insurance. They open the trunk. Hey, can we open the trunk? Yeah, sure. They open the trunk, and they find a bunch of drugs in there. The drugs are in your roommate's backpack. Can they search there? Is that suppressible? Do you get to use that? When I say you get to use that, can that be evidence in a criminal case against your roommate? Maybe if it's established that you had dominion, control, and authority over the area searched as well. So it depends. A lot of the answers tonight are it depends. So that depends. That possibly could, but it would have to be established that you had the authority, you had control, you had possession of that item, and were able to give the authority to search it. Okay? Now, anybody been through vehicle checkpoints? Okay. What do you think about those? Think those are fine? Okay, vehicle checkpoint for DUI, is that okay? So just stop, have something there, everybody stops and gets checked for DUI. Is that okay? Okay. That's okay. There's case law that says it's okay. They say it's no, but the reason is because it is not directed at one person, so it's everybody's being treated the same. I mean, that's a short answer. There's a more complicated answer. What about they stop everybody and they check for drugs? Case law says no. You're right. Case law says no. All right. They stop the vehicle and they check if you are transporting illegal immigrants, illegal aliens. Is that allowed? Just driving down the street. There's a checkpoint. So there's a checkpoint in the middle of Cimarron on the way to the airport, or coming from the airport. Can you do that? Vehicle checkpoint for illegal immigration. The case law says you can. Case law says that is authorized, that is legal, to have a vehicle checkpoint for illegal aliens being transported. Okay?
You know what?
I don't know, they just decided. People smarter than me just decided that. Do you know what?
No. I didn't even know that, so what if I'm driving a Volkswagen Beetle?
Law says they can check it. Didn't give discretion as to the type of vehicle.
Without any reason to suspect I have.
So long as it's a vehicle checkpoint. So this is not a just stopping vehicles randomly to check. So just to be clear, this is a designated vehicle checkpoint.
That makes more sense.
So it's a checkpoint, not just randomly stopping people and asking, are you transporting people? So just to be clear on that. Thank you. All right.
Before we go on, I'd like to go back to the safety issue for warrantless searches.
Yes, sir.
And that's with regard to wellness checks.
Yes.
It seems to me that, a parent could call in for their daughter or something of that nature. But with all these prank calls these days, you could just, people could call in pranks for a wellness check on somebody that they're having an issue with.
They could.
So a wellness check, does this always fall into that safety issue where you can just go into a place?
So it depends on the facts. The law would say that that's probably okay. If you say, hey, somebody's safety is at issue, I fear for her, talked on the phone and they sound like they're having a medical emergency, the law probably says that's okay. If it's a prank call or a, what do they call that? Swatting. If it's swatting, that's probably an issue for later on for a lawyer to deal with later on. But the original search is probably okay. Because remember, we always have the exceptions with like good faith, like the officers reasonably believed that there was a legitimate emergency that they had to check on somebody's safety. So that is probably okay. But that's a good question. Obviously, technology is changing. So for example, what about wiretaps? Police just come, put something on your outside phone line. We don't really have outside phone lines, I guess, but can they just, can they hack into your WhatsApp or your Instagram Messenger? You look like you have an Instagram. You have an Instagram? No? No. Who has an Instagram? Probably on Instagram right now. All right, you have an Instagram? All right, can police hack into your Instagram and just look through all your messages?
If they have a probable cause.
Okay, they say, Officer Smith says, I think she's got something. I have probable cause. I saw her the other day. She was leaving a known drug house with a package. Can he check your Instagram?
I don't think I would be texting through the Instagram about the drugs.
You'd be shocked. You wouldn't be shocked. You'd be shocked at how many people communicate through Instagram for illegal things. Well, just by that, they can just do it.
Isn't it like a voluntary public domain? People just put this stuff out there.
Well, I'm not saying the public postings. I'm talking about their direct messages.
Once again, you need a warrant.
That's the right answer. You need a warrant. So if you have probable cause, if you have something, you write it down, you swear to it, you take it to the judge, and the judge will authorize it or not authorize it, depending on if they find that there's probable cause or not. So it's not a free-for-all. It's not a free-for-all. Now, here's an interesting question. Does Meta, Facebook, Meta, how do you say it, Josue? Meta owns Instagram, all right? Does Meta tell you about it? Can Meta tell you about it? Can they tell you, hey, the cops were looking at your messages? Anybody know? Yes?
Probably.
So I actually didn't research this, but I think the answer is probably, and I'm going to tell you why. Because every time I've signed one of those warrants, there's an accompanying do not disclose order that gets sent to Meta. So on the last page, there's an order saying, Meta, you cannot tell him or her that this warrant exists. But if that order's not there, I don't think they're going to call you and tell you, but I think they probably would, like if you ask them, they would have to tell you unless that order's there.
But
So,
what if the order is there and Meta still tells you, like, what's going to happen?
well, then they're violating court orders. And that's a whole different thing. That's a whole different thing. Okay. What about dogs? What about, and let's go to, you got pulled over on July 4th on the way to the, all right. How long did they hold you there?
Not very long.
Give me an estimate.
Like 5 or 6 minutes.
All right, so 5 or 6 minutes, okay. So what if they bring a dog in those 5 or 6 minutes, and the dog goes around your car and barks or sits or whatever the indication is? Can they search then?
If the dog alerts, I believe they can.
Okay. So Nayra, what do you think?
It depends, because you can argue prolonged detention because whether or not it was the time frame that an officer would take to reasonably write a citation for.
Well, she said 5 or 6 minutes.
I think that would be within a time frame, so
Okay.
fine.
Okay. What about if it was, the answer's yes, but with an asterisk that we're going to come back to in 1 second. What if they hold you there for 45 minutes just to write a ticket? And then magically on the 40th minute, here comes the dog and sits right next to your car. Is that okay? Okay, so that's not. They extended the stop just to bring the dog. Now, let's go back to the first part. There's some recent developments, especially dealing with like marijuana. The dog has to be, and I'm going to use a funny term, although this isn't exactly the term that's used in the case law, qualified as an expert. So they have to establish that the dog has been trained to identify a specific drug, whatever drug is found. If it's marijuana, like we talked about earlier, remember when we said that hemp smells like cannabis? So there's recent developments that say that they have to specifically show if the dog can tell the difference between hemp and cannabis. Spoiler alert, I know of no dogs that can do that. They smell exactly the same. They smell exactly the same. So that's a restriction recently. So, the overarching theme of this is we have the Fourth Amendment. I think the founders probably thought that, remember, they were used to the King of England just coming in and looking around and taking whatever they wanted, right? So they thought it was very important to have the Fourth Amendment. It's the fourth one. I mean, that's not a joke. I mean, the first one, freedom of speech, freedom of religion, freedom of assembly, guns was second. And then it's the fourth one. It's one they thought was pretty darn important. Pretty darn important. And they thought, okay, you can search people, but somebody who's neutral, a judge or a magistrate, has to give you permission to do that. The courts, and not, Judge Egan and I, but historically, like the Supreme Court, has cut back on that a lot. Has cut back on that a lot. And for good reasons. We have cars now. We don't have horses and buggies that aren't going to... We have the internet. We have different things now. But these are all judicially created exceptions. Yes, sir.
So what's the definition of search? Like, I'm going to go fictional for a moment to illustrate my question, but let's suppose a world with Superman. And he walks up to your car, and he uses your his X-ray vision, to scan your backpack and see what's inside of it, right? Sure. Would that be considered a search?
Is he law enforcement?
I don't know. But the reason I ask is it seems like a dog who is trained to detect drugs is kind of in that ballpark, right?
So the Supreme Court says that a sniff is not a search. A sniff is not a search. So a lot of this comes down to your reasonable expectation of privacy. So what sort of privacy do you reasonably expect to have? Court says, smell, you don't have an expectation to be private in your smell. You're walking around, people can smell you. You have no privacy in how you smell. Your car has no privacy in how your car smells. But this brings up a very good point. Let's talk about abandonment. So abandonment, what's that? It's exactly what it sounds like. You throw something out. You throw something out in your trash can, you put it on your curb. You're being investigated for sexual battery. That's what we call rape, sexual battery. Cops want your DNA. They go to your trash can, open it up, and there's a Chick-fil-A cup with a straw. Can they take it? Yeah, because you've abandoned that. You have no reasonable expectation of privacy there. Let's say you are now doing a hand-to-hand drug transaction. Not you guys, but imagine somebody. It's doing a hand-to-hand drug transaction. The police are watching. They see you walk away, and they start approaching, and you start running. You throw your phone, you throw your drugs. What about that? Did you abandon that property? Police are running after you. But the police are running after you. I mean, it's kind of forced. It's kind of forced. What do you think? It is abandonment. It is abandonment. So when you relinquish possession or relinquish your right to privacy, it's gone. Let's talk about cell phones. Who has a cell phone? Everybody has a cell phone. Now here's a question that used to be a 50-50 question and now is a 100% question. Who has a passcode on their cell phone? Who doesn't have a passcode on their cell phone? You don't have a passcode on your cell phone? You need to get one. Okay. So, your cell phone, well, let's do this. There's a search warrant for your house. Police say this person is involved in child pornography. They're accessing child pornography on their electronic devices. Police go into your house. Search warrant authorizes taking the phone, taking your laptop, taking your iPad. Can they open them up and start searching? The warrant says they can take them. Yes? Who says yes? Yes. Who says no? Okay. Well, she knows the answer. The answer is they probably need a separate search warrant for that to actually go into the phone. They can seize it, so they can take. So we talked about search and seizure. So seizure, they can take it, but to go into it, they probably have to establish probable cause to go into a particular phone. Like we now have the phone, we now can search it. So, yeah. What about, any questions on anything? Yes, ma'am. Let's get her a mic.
What about like Face ID? I've heard of cops just putting the phone in front of people's faces and then going through their phones. Is that allowed?
In what circumstance?
I guess if they get a...
What happened to you, child?
If they get a... No, I've heard about it and I didn't know if that was a thing that actually happened or
All right.
not.
So let's say, let me give you an example. Okay. Police come on somebody downtown, pass out in the middle of the street. They're passed out, their phone's next to them. And they're like, this person's overdosed on something, we don't know what it is. Take their phone, show it their face, open their phone, start searching and find, oh my gosh, this person took heroin. Or they took fentanyl, whatever, heroin, fentanyl, whatever you want. Is that allowed?
Does it depend on whether the phone is considered abandoned because it was laying on the sidewalk?
Let's say it's in their pocket. Good question. It's in their pocket, they take it out, they do it. Now they know this person used heroin or fentanyl. What was the first exception we talked about? Exigent or emergency circumstance, and I said think of safety, think of health, think of life and death. I'm always going to say probably. That's probably going to be okay because it tells them what drug or what anti-overdose medicine to administer. So if they have evidence that like it's for an anti-overdose medicine, okay, we need Narcan, and then they can do Narcan. So that one would probably be okay.
What about, if they have like a warrant to search a phone or a laptop and there's a passcode on it, can they like get the passcode? Like how does that work?
So then you get a really fancy lawyer to file motions, and it depends on the judge and I have one pending, so I cannot go further.
Thank you.
But I think it depends on the judge. So it's a maybe. It's a maybe. But the key is they can't force you to do it without a warrant. Okay, so when you talked about like just putting the phone up to somebody's face and doing that, like if they're investigating, if they're arresting you and they're like, hey, you might have drugs on it, just throw it up on your face, that's probably not okay. That's probably not okay. If you say, you can search my phone, then there's consent. All right? So let's talk about a situation like this. A warrant is on the way to somebody's house. So there's police are outside the house watching it, and they're about to serve a search warrant on the house. They see the guy leave. Just drive down the road. He gets pulled over. The police take him out of the car, sit him on the sidewalk, keep him there for 30 minutes, and he says, why did you pull me over? And they say, just wait a few minutes, you'll see. And he says, I have to go to class. I got to go to class. The police say, just wait a few minutes, you'll see. The detective's on their way. The guy says, I just really need to go to class. I have an exam today. And they said, well, you can go if you leave your cell phone. And he says, okay, whatever. Yeah, that's fine. I got to go. You can keep my cell phone. I got to go to class. He said, okay. There's a search warrant on the way to his house. Now, they haven't searched the phone, so just to be clear, they have not searched the phone. They just took the phone from his car, not from his house. What say you, Josue? Yes, ma'am, in the back. Have a search warrant for it? What say the phone is on? It says all electronics contained in the house.
Yeah, but that phone he took from him is in his car, right? Is that what you indicated?
It's in his pocket, in his car.
But he's not at home.
He's not at home.
So you can't. You cannot.
All right, who agrees with her?
You have a warrant for that. Yeah. It's no longer part of the warrant
Okay.
in the home. That's outside of
I agree with you. So I agree with you. So I'm not trying to give you a hard time. There's a couple of issues there, right? The first issue is the warrants for the house, to take things from the house. So he's left the home. If he left the home, and there's an exception, there's always exceptions. If he's leaving the home and the police decide we're going to pull him over as soon as he leaves because of officer safety, meaning we could be ambushed if we go into the house, that's okay. There's an exception for that. But in this scenario, he's driven miles and they pull him over, take the phone. So that's problem number one. Warrants for the house, and he's well away from his house. Problem number two, he gave consent. But did he? It's under duress or under coercion. So that consent is probably not good. Not good. So that seizure is probably not a good seizure, and they can't use that phone. Does that mean somebody gets off? Like they beat the charges, so the evidence gets suppressed, all the child porn was on their phone. Do they beat those charges? All right, is that fair? Is it fair? It's fair according to the legal system. It's fair according to the founders. So remember when I was talking about the king sending people just to take things? That's what they thought was super important. The rights of people are more important than, not more important, but are very important. So if there is misconduct, if there is a mistake that affects somebody's rights, well, that's just a consequence of following the law and following the Constitution. So there are times when the result is not what you ideally would want. I don't think anybody wants people out there watching child porn. But the law says that you can't violate, you can't cross that line to get to the end. Same reason why we have trials. You don't just arrest somebody and they immediately go to prison for the rest of their life. They have to have a trial. They have to have the state prove it beyond a reasonable doubt. Same thing here. Do we all know or have we heard of cases where maybe somebody who you think and you believe very strongly is guilty has been found not guilty? What did you say? OJ? Did you say OJ? OJ? There's a very famous case in this very building where a lot of people feel that way. She's listening. Yeah. But that's how our system works. We have ghosts? Oh. Is that me? No, is it? That's a wiretap on me. Right. Okay. Yes, sir.
Can you define better what is detained for a reasonable time?
It depends. So, for example, when we're talking about the traffic ticket, the law says long enough to write the traffic ticket. That's generally long enough to do what they need to do without violating your rights. All right. Here's one that might surprise me. Maybe it doesn't. I don't know. All right. Police are investigating a drug dealer, a drug trafficker. They see him at a gas station. They start following him. He goes through a green light, goes through a green light, and all of a sudden he starts speeding up. So he speeds up to 7 miles an hour over the speed limit, and they pull him over. Can they do that? So they're pulling him over because, well, the real reason is because they know he's a drug dealer. That's why they started following him. So can they pull him over? Let's say they pull him over for speeding. When they go to check his license at the door, they see a AR-15 in the front seat, just sitting there. And see, it's plain as day. Can they arrest? And they know. Remember, he's a drug trafficker, so he's a convicted felon. Can't have firearms. Can they arrest him for that? Yes. Okay. Even though the original reason they pulled him over, it says he's a drug dealer.
Well, supposedly the reason they pulled him over is because he was speeding.
Right. So the Supreme Court says that the real reason somebody is pulled over, meaning if it's pretextual, that's a term, if it's pretextual, so they can follow somebody and wait till they break a law if they want to pull somebody over. And that's okay. That's okay. So long as there's a legitimate reason to actually pull them over, like speeding in this case. You see a lot of times window tint. Window tint. Stopping over a stop bar. Yes, Mike Brown.
I actually got complicated when I read a police report probably 2 hours ago from Lake County.
Oh, I can't give any. You just blew your question, Mike Brown. You got to do it in a hypothetical.
Hypothetically, the police know a person who's been dealing before. They see that person get off a bus and have bags with that person. Later, they observe that person get in a car as a passenger. It turns out to be an Uber, hypothetically. And then there's a male driver. They run the plate, and they see that the owner of the vehicle is suspended for driving.
Okay.
And they drive up and confirm it's the person on their computer screen. And then they pull them over for driving on a suspended license.
Okay.
Ultimately, the person's arrested for what the passenger has in their bag.
Okay.
There's a lot going on there.
There is. And since you told me it's a pending case, I cannot comment on it. But let's talk about, y'all can comment on it. You all can comment on it. Is that pullover okay? Is being pulled over in that scenario okay? Yeah. Yeah. All right. Is the search of the passenger okay? Most of the answers today are it depends and it's maybe. So it depends. It depends on things like officer safety. It depends on things like what they see when they look in the vehicle. It depends on things like where it is. where it's leaving from, what movements somebody makes. This is a very complicated topic and very nuanced. There's a lot of factors in play. There's different rules for high crime areas than for non-high crime areas. There's different rules for movements people make before the police get there. So meaning police pull them over, see somebody moving things. There's different rules for that.
Can the passenger contest the stop?
Can a passenger contest the stop? They can contest the search.
Not the stop.
Not the, I mean, they can contest anything they want to. I don't like their odds, but they can contest anything they want to. Right? She knows the answer. Yeah. So there's things called standing, like we were talking about abandonment. The real legal exception to abandonment, not exception, but the basis for abandonment is standing. If you've thrown something out, you no longer have standing, meaning the legal right to challenge that. So standing, for example, in a broad sense, standing would be if you see an accident out on Orange Avenue, you can't sue for personal injury on behalf of the person who got in the accident. You don't have standing to do that. You have no legal rights to do that. Yes, sir.
What about searching a place of assembly, like a church? In what situation the police can do that?
So a non-home, right?
Yes.
Okay. Is it open to the public? Is it open at the time? Are things in plain view? There's a lot of factors that go into it. The easy answer is to get a warrant. It always goes back to the Fourth Amendment says you can search if you have a warrant. Now, when you don't have a warrant, the law says that's presumed to be an unconstitutional or an illegal search. But then you go to the exceptions. So the de facto is no warrant, it's illegal. But then you start looking at, are there exceptions that have been created by judges? I hate to put it that way, but that's what it is. Any other questions?
If they show up at your house with a warrant, and your vehicle is parked in the garage, is that considered part of the house, or versus parked outside or parked on the street?
What do you think?
If it's in the garage, I'm going to kind of say yes.
It is, it is. The warrants usually say anything in the house or even the curtilage outside. So, you have something in your backyard or in a shed in the backyard, that's probably okay too. What about, I guess?
Okay, question. Police need to go inside a house. It's not a dire emergency, but it's enough where they're waiting. Let's say SWAT team, they're waiting for the cops to get the warrant. They go to the judge's house. It's 2 o'clock in the morning. They're calling, knocking on the door.
The judge's wife loves it when they do that.
He doesn't wake up. Say he doesn't have a wife, so he's sleeping and he doesn't wake up, and they just can't get to him. Is it okay? Do they have to find somebody else?
They do.
Okay.
They do.
They still can't go in the house.
Right, right. So what happens is they call the chief judge. They call the chief judge, and then it doesn't end well, but for the judge who was sleeping, So let me use a little bit, technology's changing, right? Anybody ever flown a drone? You've flown a drone, sir? You ever fly it over somebody's house? All right, what if the police get a drone? Say, we're going to fly it over to this person's house, zoom in. Is it a search? What are they zooming in on? Not the inside, the outside of the house. Is that okay? They're flying a drone.
Are they allowed to fly the drone legally?
The drone is flown legally. So the police have, they fly the drone. It's over somebody's house.
If they don't have a warrant, they cannot present it as a legal evidence.
So it depends. depends on the height. It depends on the height. If it's invasive, it's the right of privacy. So all those factors play in. That's also still something that's developing in the law. So drones, things like that, infrared cameras from outside, things like that. If you have a grow house, there's heat coming from it. Depends on what the privacy is. How far are they? How invasive is it? So what about trackers on cars? Yeah, sorry.
If your neighbor gives you if the neighbor gives the police permission to climb the tree in the neighbor's yard, can he look over the fence?
What neighbors do you have? Would your neighbor tell you this? That's probably okay. That's probably okay. Probably. Yes. Do the rules change when a minor is involved as a defendant? So the Constitution applies the second you're born. So your constitutional rights apply the second you are born. In terms of, like, is it easier for a minor? Like, is it easier to search or harder to search, I guess is the question. Harder? No. No, it's the same rules. Everybody is treated the same. The penalties might be different if you're convicted of a crime, but the rules are the same. Yes, ma'am.
What if you live on the 8th floor in an apartment and you look out your window and there's a drone staring at you? Is that permissible?
Whose drone is it?
Well, I looked out the window and found a woman on the sidewalk, so I went downstairs and confronted her. She told me she had a permit. I said, not to look in my window, you don't. But I don't know.
Well, so that's a great question. And unless she works for law enforcement or the government, then the Constitution really doesn't apply in that sense. So remember, the Constitution is about government intrusion into your life. People can do things. You can't get in trouble for it, but you can sue them for privacy invasion. You can sue them. I think the law, there's something about air. Air is not like property, so they probably are going to be able to do that. But government intrusion is different than an annoying or nosy neighbor. Or random person on the street looking into a random 8th floor.
Your Honor, I have two questions. One is, two questions. First is, wouldn't that be a peeping Tom if Miss here is walking around her house naked or whatever, and someone's looking in through her windows? Wouldn't that be like a peeping Tom?
That could be a crime. That could be a crime. The question for Fourth Amendment is the government doing a search or a seizure? So we're talking about...
I'm not talking about the government. I'm talking about just a random person.
That could be a crime, yes.
Okay, and my other question was going back towards the search warrant for the electronics.
Yes.
What if the electronics are not all at that house where the search is? Like they're at mom's or at grandma's or at my cousin's, or I sent it to my friend in Puerto Rico, whatever. For whatever reason, I gifted the tablet.
Why are you sending stuff to your friends? No.
I've never sent any electronics.
So the warrant has to be to a specific. It has to be specific to time, to location, and what's being searched. So they have to say specific. So oftentimes, like, we'll get a warrant, and it's the same description every time. It is a building on the corner of Colonial and John Young. Anybody know what building's on the corner of Colonial and John Young? It's the Orange County Sheriff's Office. So they take it, and they bring it to the county sheriff's office, and they hold it there until they get a warrant. And I can't tell you how, the first time, when I first became a judge, I was like, what is this location? Oh my gosh. Like, why is it there? And then the next one said the same thing, and I finally figured it out. I'm a slow guy. But it has to tell you the location that they are searching with specificity. So if they put the wrong apartment, can they search? If they get to the house, they go, it's supposed to be 805, and they put 803 on here. Well, yeah, it's good enough. Let's go in. No, probably not. If they realize it beforehand. What if they realize it after? Probably okay, right? Yeah, they have good faith. They have good faith. So if they know it's a mistake and still do it anyway, bad. If they just make an honest mistake and do it, then it's probably good. Meaning valid, not good, but valid.
So how would you know if they made a mistake or not before?
So this is my clerk, Josue. Josue sits with me every day and knows what the answer to that question is. They come in front of the judge and challenge it, and the judge will ultimately decide if people are credible when they testify and it is good faith, or if it's bad. Don't say anything, Ms. Perez. But that was a good question. What about NCCU's finest? You got any questions?
No questions, Your Honor.
All right. Anybody else?
How do you handle like warrants that are like during really odd times, like you're talking about coming to your house? How do they handle those?
So in the Ninth Circuit, we take turns. So there's 70 now, 72? 72? Oh, yeah, Julio. So there's 72 of us now, and we have split it between weekends and weekdays, and I'm just going to make it easy, every 72 weeks, although that's not exactly sore subject. Every 72 weekends, we have one weekend, and every 72 weeks, we have 1 week to be the signing judge for that. We have an emergency phone where I have no idea how they make the ringer so loud, but they will call you for emergency warrants. Otherwise, you have to monitor an electronic system that will upload warrants, and we sign them electronically and do it that way. So in an odd time warrant, we have the law enforcement contact the person who's on call. Kind of like doctors or nurses, we're on call once every year and a half or so. And so we sign them. On some occasions, like law enforcement will know a judge, will have their contact information, and they'll call them and ask them, hey, can you sign this for whatever reason it is, maybe more convenient or whatever. So, but the default is the duty judge. That's a good question. It's a little inside baseball. We're inside the courts, a little inside the courts there. Yes, sir.
In the scenario we're living in a high rise over here, and a drone is out there, like pretty obviously, just looking in your home. What if you shot that drone out of the sky? Because I shoot skeet and I wouldn't miss that drone. But
I'm going to tell you this: if you shoot, don't miss.
I'm probably in trouble in that scenario, right?
Maybe. It depends.
I shoot ski, so I'm not missing that drone.
Well, so there's factors at play. There's like what we call the castle doctrine. Like if you feel like that's going to creating an imminent danger to your home. So if there's like a gun attached to it or a laser, then I'm not saying it would.
Like it just is, like they're videoing the inside of your house, and it's obvious, or you know, I mean, you don't know if it's recording or not, but they have ultra cameras.
It depends. I mean, I know that's a bad answer, but it depends. You're probably going to end up in court. I can't tell you which side you're going to end up on. So, hi.
One more question.
Yes, sir.
A subject near and dear to my heart. What about student lockers and student backpacks?
Do students have an expectation of privacy to their locker?
I asked you first.
Well, I'm asking the group.
I think they do have an expectation. I mean, I think I know the answer that they don't have it, but I think as a young person, they probably think that they do have some expectation.
Well, they probably think they have a lot of rights, but no, there's no expectation of privacy to a locker. The backpack might depend. So the backpack could depend on if they're at school or not at school. It could depend on whether there's been a report that gives them a reason to search it. So are you a school teacher?
I'm sorry?
Are you a school teacher? Or are you
I'm a senior administrator.
Okay.
And I oversee criminal law.
So it would depend. So for example, I would assume, and this is just an assumption, that there's some sort of student handbook that says that searches of backpacks are okay, and you're consenting to it. So there's probably consent there to search the backpack. It's an interesting scenario because although school employees are, if in a public school, governmental actors, they're not law enforcement. So does the Constitution apply in that scenario? School administrator, not law enforcement. But they're a government worker, so the Constitution applies. The Constitution applies to government actors. So you have to abide by the Constitution, but there's probably been a consent because they signed the handbook. The locker, I don't think you have an issue.
And they also serve as in loco parentis.
I don't know, stop using these fancy words.
What about cell phones? Children, teenagers get cell phones on the high school property, per se.
So it depends again. I don't know what the handbook says. So well, because they're consenting to it. Now, if somebody goes to them and says, you need to show this to me, and it's not in the handbook, that's probably coercive or misleading, maybe. So I would say it depends. Is that in the handbook? Are cell phones in the handbook? All right, so in Orange County, okay. I would assume that this is usually what happens.
Judge Madrigal?
Yes?
Look at the clock.
All right.
I want to thank you very much.
All right.
It's a fantastic. If you indulge me just for maybe a minute and a half, though, you can say, by the way, the better approach at any school, most schools don't even have lockers anymore that I can see, but the lockers clearly you can go in without permission. The better approach regarding backpacks is to seek a warrant as well as a cell phone. But as a practical matter from someone who spent a lot of time in juvenile delinquency court, kids consent all the time. So, can I search your pack? Yes, Mrs. Smith. Yeah, so kids will usually give you permission, okay? But I think if they don't, the police officers would know this at the school resource officer, probably best to get a warrant, especially if the parent isn't around, okay? But as you can see, this is the Fourth Amendment right here. It's literally one sentence. It's a bit of a run-on sentence, but it is all gray area. Everything we do with respect to searches and seizures operates in the gray area. Basically what this says is we cannot unreasonably search persons, houses, papers, and effects. Can't do it unreasonably. Anytime you see the word reasonable or unreasonable, it's open to broad interpretation. So everything is fact-specific, and Judge Madrigal, I thought, did an excellent job of showing that to us today. So I want to thank you all so much again for being here. Next week, a problem-solving court with Judge Lattimore, and then 2 weeks would be divorce court. Yes, ma'am.
Can you just spell your name, please?
Madrigal. I have an uncle named Bruno. We do not speak about him, though.
Thank you all. Drive safely.